Hello, everyone, and thanks so much for joining today's webinar on leveraging trade dress. My name is McKenna. I'm an editor at Utah Business, and before we get started, I have just a few housekeeping notes to mention. This webinar is being recorded, and it will be available within the next 24 hours on utahbusiness.com for you to rewatch, send to your friends and colleagues, whatever you'd like. That'll be utahbusiness.com/video. Also, we will be hosting a Q&A at the end of this webinar. So if you have any questions along the way, please type them into the chat or Q&A bubble, and we will answer those at the end of the hour. Without further ado, I'd just like to introduce you all to Parrish Freeman and CJ Viverka, shareholders with Mashoff Brennan. Thank you both so much for being with us today. I'll let you guys take it away.
Hey, thanks, McKenna. This is Parrish Freeman. I'll let you guys get acquainted with my voice. I have CJ Viverka with me. We're members of Mashoff Brennan. We're an intellectual property firm, and CJ and I specialize in the litigation side of intellectual property. So we'll be talking to you from that perspective. And we're going to talk to you today about how to leverage your trade dress rights. And these might be rights that you have already, or they're rights that you are trying to develop. And we're going to try to give you some ideas about how best to do that.
This is CJ Viverka, and I'm going to be helping Parrish with this presentation. Here's a little pictures of us probably 10 years ago. I'm sure we don't look like this anymore. So we'll go and launch straight into the presentation.
So we'll start with something that seems simple on the surface. It's the definition of trade dress. And really simply stated, it's a source identifier. And it's just like a trademark in that way, if you're familiar with trademarks, but we'll talk about all that stuff in just a second. It allows consumers to associate a product or its packaging with a single source. They may or may not know who that source is, but they know it's a single source. And the definition that's developed in the case law, this is from the Supreme Court, and it's been in play for many years, is this overall image and appearance, and it may include features such as size, shape, color, or color combinations, texture, graphics, and even particular sales techniques. Although the overall image and appearance language should not be confused with overall look and feel, courts tend to frown on that as being a little bit too vague. Most courts these days demand something of a laundry list. The shorter, the better. If you can, that'll help you have broader rights, but you need to be able to articulate and itemize what the components are of your trade dress. So this is a slide that just kind of gives you a high-level overview of the types of source identifiers. You're probably all familiar with trademarks already. That's a symbol or a word that you use to identify your goods and services. But we're going to talk about trade dress and the two different branches really that we'll focus on that exist in trade dress law. Product packaging, you see the images there of the Wheaties box and the Fiji bottle. And product design. So that's the examples there, the Pepperidge Farm Goldfish and that Ferrari Daytona.
Yeah, I'm glad you got the Daytona in there. And we got it right. So before we launch into some of the specifics, now that we kind of talked about the difference between trade dress and maybe even trademarks, one of the I'd like to just talk for a second about the value of trade dress. This may be intuitive to many of you, but it really is because it's so visual, and if you've done it consistently, it's been out there for a long time. So it really does play a role in providing recognition to your goods or services, which hopefully have a reputation for having high quality. But after you've used the same trade dress for a while, it really does create this sort of heritage sense, long-lasting sense of your brand. It really is an important part of your brand. And and the goodwill associated with that brand, and probably more importantly, it distinguishes you at just a glance from your competitors. And one of my favorite examples is the 7 slat grill that first appeared on the early Willys Jeeps. Now the Jeep trade dress and trademarks and the Jeep brand have been owned by a number of different companies since World War II. I believe that the owner right now of Jeep is maybe Fiat, but consistently for 70 some years, they've had these 7 slots for their grill, which they've been very consistent about and have created a strong and certainly well-known trade dress. If we want to be a little bit more specific and put some dollar amounts on it, here are some awards that plaintiffs have gotten in trade dress cases. Herman Miller, that was a case involving 2 types of Herman Miller chairs. They seem to be pretty ubiquitous in office atmospheres. So here's an image of those there, but there was a lawsuit which ultimately yielded over $3 million for Herman Miller. I don't know if attorney's fees were included in that case. They might have been.
Full disclosure, I'm not confident that these chairs were the ones involved in the lawsuit. These are representative chairs.
Okay.
Or maybe they're the ones involved.
And there was another case between Mixed Chicks and Sally Beauty. This related to an inexpensive product, but high volume product where the trade dress was principally bottles, the color and shape of bottles for shampoo and other hair care products. And then even another case, the Clearline Technologies case with rooftop supports. And there was an award there of almost $6 million. Now you want to bear in mind that these numbers are just awards, probably of their damages as they relate to one competitor. Certainly this would represent only a fraction of the monetary value of a strong trade dress.
So as we said a minute ago, or as I said, CJ and I are both litigators. So we come at this from the litigation perspective. So we're talking to this audience about how to best prepare for enforcing their rights in litigation. But really, you want to develop trade dress rights as an asset that you can use, and also as a source identifier to let your consumers know that their goods and services are coming from you or a singular source, and that they can trust the quality. But here is what you need to know if there comes a time when you need to enforce your trade dress rights. And this will be most of what we're talking about here today, because this is the most important thing. If you don't have this ready to go when the time comes, then you'll regret it. So you need to be able to show that your trade dress is distinctive, and you can do that through inherency. It's either inherently distinctive or it can acquire distinctiveness. And we'll talk about both of those in a minute. You have to show there's a likelihood of confusion among consumers as to the source of the competing products. And you also have to show if the trade dress is not registered. And we'll talk about registration in a little bit too, but we're assuming this audience has not registered any trade dress. So if your trade dress is not registered, you also need to show that it's non-functional.
And here, we're reluctant to try and get into the weeds on the law, and we'd like to do our best to avoid that, principally because we just want to help provide you with tools as you're either developing or trying to evolve your own trade dress. And with respect to these elements that you're going to have to prove if you're ever in the position of having to enforce your trade dress, we wanted to focus on the distinctive nature of your trade dress and the non-functionality, because these are things that you can control. These are things that you can kind of work on at the outset or wherever you are going forward in connection with developing your trade dress. Likelihood of confusion is largely controlled by your competitor's behavior, and that would be down the line when you really wanted to force it. But for today, we just like to give you some ideas about things that are in your control and that you can work on to develop a more valuable and a stronger trade dress. Now, one of the principal and initial questions that's really important that you need to consider, and that is your trade dress sort of this embodiment of the visual embodiment of what your brand is that going to be embodied in your product itself or in the packaging for your product? And the reason why that's important is that there is a little bit easier row to hoe. Sorry about the farming reference with John Deere up here. I just couldn't help myself. But there is a little bit easier row to hoe when it comes to packaging, embodying your trade dress rather than the configuration of the product itself. And that is you have the opportunity to choose or try an inherently distinctive trade dress. That is a somewhat vague term, and we're going to help try and suss it out here in a minute. But if your trade dress is embodied in the actual design of your product, you're going to have to put a little bit more effort into it, at least in the enforcement side, because the Supreme Court of the United States has held that if you have a product configuration, if it's your actual product and your trade dress is embodied there, then you're going to have to show that you acquired this distinctiveness, that you acquired the association in the mind of consumers of your trade dress with the product. It's just a little, it creates some more work in terms of enforcement. And one of the bottom line that we're going to tell you is that particularly in terms of developing and maintaining your trade dress, what you need to, some of the steps you could take to help document and record that your trade dress acquiring distinctiveness are things that aren't too hard to do if you get on them early. And probably what we're going to counsel is that because these things are pretty easy, that the easiest course or the best course of action is going to be assume that you need to show that you've acquired distinctiveness, and we'll get into some of the easier steps on how to do that as we proceed here.
Yeah, courts have shown themselves to be pretty dubious of product design, trade dress, because they see it as, attempting an end run around patent rights. So they hold you to your proof in that and make it tough. But I'm going to talk first about inherent distinctiveness. Like CJ said, at first blush, it's going to sound like the preferred path, because that's what, that's all you need for product packaging. And it can, it seems like it could be a shortcut. You do have to present evidence to establish inherent distinctiveness, but like I said, on its surface, it sounds like it's not that tough, but the cases show that it's really not as easy as it looks. So there are a lot of different definitions floating around out there. All of this verbiage is pulled from case law. We just paraphrased it and took out the citations to make it a little bit more user-friendly. But this first one is from a case that CJ and I actually worked on. It came out of the 10th Circuit, where the court said that product packaging trade dress can be inherently distinctive because the very act of encasing a product in a distinctive packaging serves to identify the source of the product. So that's kind of circular, not terribly helpful. What is the distinctive packaging? There's another definition that pulled out of a treatise, where it's reasonable to assume consumer predisposition to take packaging as an indication of source, that inherent distinctiveness will likely be found. Again, not remarkably helpful. Let's go to the next slide. The test is developed over the years. I mean, it started many years ago, but it's really taken hold now. I think it's called the Seabrook test. And this is a distillation of it. It's got like 3 parts, but this is kind of a summary. Is the design, shape, or combination of elements so unique, unusual, or unexpected in a given market that one can assume without proof that it will be automatically perceived by customers as a source indicator? So, Fiji Water was able to establish that by showing no other water bottles were using what essentially is an octagonal shape and that distinctive, which made their product distinctive in the market. And they were able to avail themselves of their inherent distinctiveness. What's not inherently distinctive and where they really, hold your feet to the fire is if there's a lot of other people doing it or even one other person doing it. So this is an example. This the Chippendales dancer costume. It's not inherently distinctive because the collar and cuffs are not so unique, unusual, or unexpected in the market because Playboy was using the same setup. Let's move on to the next one.
Okay. With respect to the other kind of distinctiveness, acquired distinctiveness, this is where you choose a trade dress that for whatever marketing reasons or whatever business reasons you have, has a particular, and I'll use the term look, but has some sort of that's eye-catching. And then over the course of consistently using that trade dress and what they'll call policing your trade dress through trying to keep others in the market from using your trade dress over time, the elements that you chose for your trade dress really make that trade dress a source identifier for your products. When consumers see, in this case, this is a Herman Miller chair, when they see the shape of the armrests and the fabric and the color combinations, they're like, oh, that's a Herman Miller chair. And hopefully they'll be able to distinguish, oh my gosh, that's a Herman Miller knockoff. But this is distinctiveness that has been acquired through your own efforts. And there are ways that you can, there are efforts that you could take to make this level of distinctiveness stronger and harder for your competitors to copy as time goes on.
So where we're going with all this, like CJ said, is that we think that it's wisest for you to go ahead and prepare to prove up your trade dress rights through acquired distinctiveness without planning on relying on inherent distinctiveness. And the reasons are several, because as I said earlier, inherent distinctiveness that's no lock. It can be difficult to prove. Acquired distinctiveness is expressly required for product design trade dress, as we've said. It's required in this circuit, in the 10th circuit, for packaging color trade dress. That's not consistent across all circuits. Some allow inherent distinctiveness to be at least attempted to be established, but the 10th circuit has some precedential case law requiring the contrary. And it's certainly likely required that you're going to have to prove acquired distinctiveness in any case that's not clearly involving product packaging. And that's because of the admonition from the Supreme Court in the Walmart case from 2000, saying err on the side of proving acquired distinctiveness. And an example here would be the theme of this a theme restaurant design. We've got a picture there to illustrate that, but also the image from earlier of the John Deere tractor. It's green and gold. Everybody knows green and gold. Is that a package? Is that a product design? It's not really a product design. It doesn't have anything to do with the design of the product. It's somewhere in the middle. So if you're being smart, then you go ahead and prepare yourself as though you're going to need to prove acquired distinctiveness. which is also called, by the way, secondary meaning. CJ might have mentioned that. Those two terms, I'm going to use them interchangeably. CJ probably will too. They're not necessarily interchangeable in the case law, but for purposes of this discussion, secondary meaning, acquired distinctiveness, it's the same thing.
And just before we move on to the next slide, I think a number of you might recognize that the trade dress that Cafe Rio was attempting to accomplish here. This is, I think, their first restaurant that was on 33rd South and close to Wasatch Boulevard, which isn't there anymore. They moved down the street a little bit, but I like this image because it reminds me a lot of lunches.
Okay, here's the heavy lift. This is where we'll spend a fair amount of time. This is what the case law says that you need to, evidence that you need to have to establish secondary meaning. You don't, it's a non-exhaustive list. There can be other things that you can try to come with to try to prove your use of a particular trade dress as a source identifier. And you don't have to have all of these things. It's going to be very fact dependent. And the facts of the case are going to dictate the outcome. So just to scan through them real quick, and then we'll touch on each one individually. We're talking about the length and manner of the trade dress's use, the nature and extent of the advertising, the efforts made in the direction of promoting a conscious connection in the public's mind between the trade dress and the particular product. That's a very important one. Actual consumer confusion, if you have it, proof of intentional copying, if you have it, and evidence of sales volume.
Well, let's talk about the first one for a minute. And I think tying it to, my personal experience when we have clients come to us and say, you know what, I have a restaurant, and you know what, there's a lot of buzz about my restaurant, and I've got, this is my look, this is my trade dress. I have a new competitor in town, and they really are trying to, in my opinion, trick people into thinking that their restaurant is mine, or that it's necessarily the same restaurant. And this list, which comes from case law, is pretty accurate, because as we go down asking new clients and answering their questions about how we can help them make their competitor change their, whatever it is they're doing to make them seem like they're you instead of one of your competitors, they really do kind of track the questions that we ask. And for number one, it's pretty simple. So let's say in the context of a restaurant, like this old image of Cafe Rio that was on 33rd South. What we'd usually say is, once we've identified what you believe your trade dress is, like, okay, when did you start using it? And they're like, well, we started using this back in 2010. We're like, okay, let's see what we have to prove that up. And it may turn out that you don't have anything except maybe a photograph from 2 years later. So as you go out, when you're developing your trade dress, do your best to record in a way that you can find this evidence later, because probably 10 years later, if you had a really successful trade dress that someone is going to try and rip it off, some evidence, even a photograph that you can place in a particular time period that shows most or all of the elements of your trade dress, and you can at least put a bookmark in time that says, I've been using this trade dress for 10 years. And here's evidence that it's been at least 10 years. And that is absolute solid gold when you're trying to put together evidence to get a competitor to change their behavior in light of what is your protectable brand. So now in connection with number two, the nature and extent of advertising, this may be something that you would do already. but to the extent that you have spent advertising dollars and that you have actual examples of advertising that include your trade dress throughout the years, you really want to try and keep that, the records of that, because they can really help show not only the sort of time frame, but that your trade dress has been consistent as time has marched on.
So, and on that note, if the trade dress is something that is not, it includes components that are not visible through a two-dimensional photograph, and the advertising is of the product and the trade dress is incidental, that may not help you a whole lot. We had a case involving planners. They were colorful, decorative, playful planners. You know, they're functional, they're utilitarian, but they're also fun and they have stickers and all that kind of stuff. And when we argued this, we pointed out that all the advertising that showed the planners didn't really show or highlight all the elements that the plaintiff said were part of the trade dress. And we won the case. We prevailed at the district court level and again at the circuit court level. So I think the court bought what we were selling on that one.
And this one seems, number 4 seems pretty intuitive, but you would be surprised to know that I've had a number of clients when they've come to me and say, you know what, my customers, consumers out there are confused now between my competitors, let's say restaurant, or my competitors' products and mine because they're using my trade dress. I'm like, okay, tell me who was confused. That's great. That is really strong evidence. And it's like, well, I got a call 2 years ago and somebody was asking for Costa Vida instead of Cafe Rio. And if you ever have an instance of someone actually being confused, you want to make a note of that the best way that you can, so you have that in your back pocket if you need to enforce your trade dress, because evidence of actual confusion usually isn't there just because of the reason that we're talking about, that it doesn't always impress upon your mind that it's something you need to keep track of. But if you have any evidence of confusion, even if you're not going to use it right now, you want to keep track of that.
I want to back up to 3 for a second, because quite apart from relying on the incidental use of your trade dress that just happens to appear in your advertising, you can make real and concerted efforts to draw the public's attention to your trade dress as a source identifier for you. And even if they don't take away from that it's a source identifier for you, they know it's a source identifier for some single source, and that's all you need. So that's something that you should really think about doing in your advertising. For example, I don't know if this really happens, but looking at the John Deere, if they say, look for the green and gold, always trust the green and gold, something like that. That shows that they're highlighting their trade dress and not just saying, hey, buy a really functional and nice tractor from John Deere. They're great. I'll move down to 5 real quick. So that one is interesting. If you have intentional copying, that can go a long way to putting a defendant in trouble. On the other hand, if it's copying of a product design, there are great arguments to be made that, hey, that's a non-patented, very useful, very attractive, very popular design, and I want a piece of the action. So, it's not protected by anything, and it's as a product design, you can't get the, trade dress rights and have them be a surrogate for patent rights and keep me from doing that. So in the case that I was mentioning a moment ago, we had evidence of what the other side was certainly calling intentional copying. I will say intentional inspiration, but 6 one way, half a dozen the other. And so we had that hands down. We just had to own it and say, yeah, this happened. We decided we wanted in on the game. And that was something that you would think could have really carried the day for the plaintiff, but it ended up not, because they didn't have evidence strong enough to show their use of the alleged trade dress as a trade dress. It was really just the incidental design of their product, and they just said everything about this product is a trade dress or comprises the trade dress. And both the district court and the circuit court said that's not enough.
And one of the this last item here, evidence of sales volume, seems pretty intuitive, and courts will use that as evidence that your trade dress is associated with your products to the exclusion of others or secondary meaning. And this is usually something that clients will have good records about. But one thing to keep in mind, if at all possible, say, let me give you an example. You have one product line that uses your primary trade dress and perhaps another product line doesn't. You're going to want to be able to separate out sales that are more tightly associated with your trade dress than perhaps sales that are more distant from that.
So we're going to turn now to functionality. If you remember from a few slides ago, that's the third thing that you need to show in order to establish your trade dress rights, that your trade dress is not functional. This is for your non-registered trade dress. It's not functional. It's a really, it's an abstract concept because, of course, a chair is functional. Of course, a tractor is functional. But that's not what it's talking about. It's talking about the things that make the trade dress. So is painting the tractor green and gold, is that functional? What, does that provide a utilitarian benefit? The aspects of the chair, I'm sure there are plenty of arguments had over this, but can the shape of the arm or the fabric used, are those functional? And so the case law has tried over the years to develop a few tests. All of them come from some particular situation. They're trying to capture into words a particular situation. So here's three of them. And I think these are the main three that are in play now. These are from the Supreme Court. A product feature is functional and can't serve as a trade dress if it's essential to the use or purpose of the article. And I've got a picture there of this, I'll call it a speed bump, but it's a plastic thing that you put down on whether it's in a hallway, if it's indoors or on a road, and you're trying to cover up cables that got to run through it because you've got some kind of, concert or something like that going on. And so the color scheme is dictated by either practicality, because it has to be seen. I think there might even be regulations in place. This is from a case that CJ handled. So I don't, if he wants to intercede with that.
Well,
fact,
it's just that under different OSHA standards, this particular color yellow was used to connote that there was you needed to be cautious and worry about electrical shock hazards.
Yeah.
So it was a logical and maybe necessary choice for this particular product.
So pretty much everything about this device is essential to its purpose. It's a ramp. You got to get over it. You got to wheel carts over it. It's got a hinged opening to give you access to the cables running through it. It's got tunnels running through it for the cables themselves. So that is very clearly a functional trade dress. The next one is if the alleged trade dress affects the cost or quality of the article. So if the thing that you've produced is the product of the most efficient or most cost-effective way of doing it, then you can't have a trade dress and keep everybody else from using, having the benefit of that most efficient way. The last one is it something that the exclusive use of that thing would put competitors at a significant non-reputation related disadvantage? And the example of that comes from this case, the Supreme Court case of Traffics, where it involved these road signs. And if you look down at the bottom, you can see these two stanchions. Those are springs, and they allow the sign to get buffeted by the wind and not blown over and not blown down a mile away. It just, bends and then pops back up. And if nobody else gets to do that, then that puts the competitors at a significant disadvantage, that they are not suffering as a result of some bad reputation that they got otherwise. Another kicker in that case, by the way, was this spring setup was patented. It was part of an expired patent. The patent had expired. So this is an example of what's not too uncommon in product design trade dress cases, where they're really trying to leverage that concept, product design trade dress, as a patent. They want to get people to stop doing the thing that their product does. And that's functional. So you can't have a trade dress in that. And one last one is from the Ninth Circuit decision in the Leatherman case. It's been probably 20 years now. And this is paraphrased, but it's more or less the court's language. The trade dress, it's true, that does have to be viewed as a whole, but where the whole is nothing other than the assemblage of the functional parts, and where even that arrangement and combination of the parts is designed to result in superior performance, then the design's functional and you don't have a trade dress. And I think that one's interesting, because if I think of something that is, when I first started to learn about trade dress, about that time, probably late 90s, that's one of the first things that would come to mind. You look at that and you're like, that's a Leatherman. I know what that is. And they don't have trade dress rights, or at least didn't as a result of that case. They might have done something after that I don't know about.
So let's kind of go back to where we started a little bit. And if you'll recall, I wanted to talk about some of these, some of the elements of the law of trade dress, what you're going to be up against if you need to enforce your trade dress down the road, and what sort of benefits you get from registering your trade dress with the trademark office. Now, registering a trade dress is very similar to filing a trademark application. In fact, it's even on the trademark office's site called a trademark application. But the benefits that you get from that are with respect to whether or not your trade dress is distinctive. If you get a registration for your trade dress, then you will get a presumption that your trade dress is distinctive. And that can go a long way, particularly if you're trying to prevent a competitor from using your trade dress. And maybe even more importantly is you do not have to, it's not even a presumption, you do not, for a registered trade dress, have to show that your trade dress isn't functional. And particularly if your trade dress is embodied in a product that's designed, this can really help you a lot. And it takes away a substantial defense that your competitor would have if you are in a position to assert your trade dress against them, and they're trying to knock you off. So that sort of begs the question, why would you ever not try and register your trade dress? Why are and I can tell you that the vast majority of trade dress cases are trade dress that has not been registered with the trademark office. Why wouldn't you do it? And the answer really is sort of a balance, and that is, gosh, if you try and register your trade dress with the trademark office and ultimately you aren't successful down the road, that's going to be some evidence that your competitor may be able to use as a defense if you want to enforce your trade dress against that competitor. It's not game over for you. It's not game over in terms of, oh, this must not be a good trade dress, I better try and figure out something else. It's just that it's something that you want to consider down the road. And it's also, as most of the case law where companies have asserted their trade dress against competitors, it's certainly not necessary to have it registered. But if you have a distinctive, if you have a strong trade dress, it's a good idea to try and register it, because if you do have that registration, it's going to save you a little bit of trouble enforcing it down the road.
Another countervailing point though on registration is, and again, this is just like CJ said, it's not a killer, but it could make things a little bit ticklish. You know, when you file a trademark registration, you have to list your goods and services. So you might do that, and it might turn out that that morphs a little bit over time, and you're using it in a much broader way with a much broader set of goods than you initially registered for. And the example that comes to mind, and again, this is kind of, maybe it doesn't matter because I certainly wouldn't want to tussle with Tiffany and Co. But Tiffany's, the robin's egg blue that everybody knows, you know, if you're going to start a new business, you know better than to, you know, make all your packages robin's egg blue, I imagine. Well, their registration on robin's egg blue is for catalog covers. That's their goods and services. So that doesn't mean that they're not going to win, but it just makes things less clean when you go to a certain. So for instance, you know, are you completely relieved of the non-functionality now, or do you have to prove non-functionality as to some component? It muddies things up. All in, I would think if you have everything that you need, you've been using it long enough, and you feel, you know, 80% certain that you can show the trademark office that you've got either everything you need for secondary meaning, or maybe you've got everything you need for inherent distinctiveness, then go ahead and do it. Because I think it would be better to litigate just the question of likelihood of confusion instead of having to deal with, you know, distinctiveness and non-functionality.
Okay, so here we kind of want to summarize by talking about that, really the concepts that if we could, we would want you to take away from this webinar. And that is, what can I do to help develop a strong trade dress that I could use to distinguish my goods and to keep my competitors from trying to knock off the segment of the market that I've kind of carved out for my services and my products. And we'll this will conflate into our sort of question and answer period here at the end. But one of the and this seems kind of obvious, best things you can do when you're going to pick a color combination or some shapes or anything that you're going to lean on to distinguish your brand, you know, pick things that are unusual, pick things that are eye-catching, pick things that aren't intuitive in your industry, and then try and stick with that over time. If you have a combination of trade dress elements that you've used and you've been careful to continue to use them over years, you're really going to put yourself in a good position to have a strong trade dress.
Well, and this list is essentially, you'll probably notice it's tracking a lot of what you have to show to establish your secondary meaning. So the takeaway really is track all that stuff meticulously, or as meticulously as you can. So, you know, you want to market your product in a way that highlights the distinctive trade dress, and keep track of the sales related to the specifically trade dressed goods, you know, whether it's packaging or design, and document all that good press that you get. And, you know, you can even seed the press, but by, you know, talking to the folks that are covering you and saying, you know, be sure you highlight my trade dress, or, you know, refer to my product in the right way.
And you know, you might ask yourselves like, well, how do I highlight my trade dress? And, you know, or I guess another question would be, isn't any advertisement for my products going to highlight my trade dress? And an example that I'd use is, say that you are a software company and you want to develop a particular trade dress. And that trade dress very likely is going to be embodied in your graphic user interface. And, you know, say, for example, if that is also a web page, how the different pages transition to each other, what colors are used in combination to represent different ideas and different themes, so that if you would carry that theme, that trade dress through in parts of your products that, you know, really aren't that easy to use in advertising. It's like screenshots for advertising. It doesn't seem to be always a great fit. Make sure that you employ it in other ways that is consistent with your trade dress in your marketing. Like, for instance, Microsoft does a good job of this, in that in their main window that they kind of show with their advertisements, and also still in their products, they will insert as panes to that window the colors that they use to associate with their word processing program Word, with their spreadsheet program Excel. Excel's green, Word's blue, their presentation software PowerPoint, they use red. And I am not, someone told me that Microsoft Notes uses yellow, but if you see that window sort of in their advertising, when I mean that their actual representation of a window with those four colors, that gives you a good idea of how you take the trade dress for your individual product lines or a suite of products, and then incorporate that into advertisement.
So the last two, you know, are pretty self-explanatory. Just watch the market. Look out. I mean, because you do have an obligation. If you want to hang on to these trade dress rights, you have to police the market. You have to go after folks that are getting too close. So you want to look for signs of imitation, and you certainly want to catalog instances of confusion when they arise. So we've reached the end of our prepared slides. We're happy to take questions if any have rolled in.
Yeah, so we've got a couple questions in the chat. I'm not sure if you are able to see them, but earlier in the webinar, Paul asked a question that if you have answered, maybe you can just reiterate the answer. He had a question about how to police your trade dress when your product is newer and perhaps hasn't acquired secondary meaning yet.
Sure, that's a good question. In policing your trade dress, that the principal way to police your trade dress is to ask your competitors not to, if you see a competitor that's using the elements of your trade dress and you've been intentional in connection with, you know, combining those elements, is to contact competitors, ask them not to use these color schemes. Now, I understand when companies are young, and when you're just starting out, you may not have the resources to always follow through with requests or to change their, we'll call it marking, or to threaten them with lawsuits. But the principal way to police your trade dress is to keep your customers from it. Do your best to keep your competitors, from using it. And, you know, one of the best ways to sort of brush someone back, particularly when in the early stages when you may not want to get involved in a dispute with another company, is just say, look, you need to do this so that your customers know that they're purchasing your product rather than mine. And surely you don't want to create or even live with any confusion between our products. So I think what you're kind of driving at is what's the bet? It is, how do you police your mark? And unfortunately, it is with respect to asking your customers, your competitors, not to use your trade dress.
And there's another reason to police, which is, if you send that letter and you ask them to stop and they send you one back and say, well, why should we stop? We've been doing this for 20 years. Maybe they haven't been doing it with a lot of girth and they've been, confined to a small area, but maybe they're just down in the corner of one state and crossing into another state. So they're good for federal registration if they want it. And then there you are. And I think that, that might sound like a real bummer, but it's actually a good thing because you'd rather know about that. And you'd rather go ahead and find out and do what you got to do to adjust your look and avoid their look.
Or another option in those instances, particularly when it's a competitor that you really didn't know about, perhaps they're not even that tied to their own trade dress, is then you might have an opportunity to have them assign their trade dress to you if you're a lot more serious about it than they are.
Okay, perfect. Thank you. We have another good question here. It says, it seems like developing a strong trade dress is something that requires planning and maybe years of execution. Where is the best place to start?
Where is the best place to start? Well, you just start by deciding what you want the look to be. And sometimes you're going to be, your options are going to be limited by what it is that you're marketing. So like the John Deere tractor, you can't put in a package. That's not going to be, you're not going to have product packaging trade dress on something as big as a tractor. So you're going to be limited to product design. What can you do within that framework? Well, if you're really limited to the product design sphere, go ahead and make it as absolutely functional and the best, most efficient, greatest thing ever, but put a flourish in there. Put something decorative, something ornamental that lets everybody know it's you. I think of an example as, a knife with a great handle. It's got a great grip on it. It's got great knurling. None of that is trade dress. But if you put something on the end of it, that's a little bit of a flourish, a little carved, figure or something like that, that lets everybody know that that's the special knife with the cool handle that I can really grip well. I know it because it's got that little flourish on it. Well, then people that are going to knock you off are going to try to copy that flourish too, and you can stop that. You can't stop them from, copying your great grip unless you got a patent. That's a whole different conversation. But you can stop them from using your decoration, your ornamentation. And if they don't have that ornamentation, then you can outmarket them by saying, well, don't buy the ones without this cool little ornamentation that I put on all my stuff.
And I think, one of the most important things you can do is just be careful and mindful of being consistent and trying to use your trade dress over and over again in connection with your marketing, with your packaging, with even your business cards, your colors in your website. And I could think the more consistent you are, the easier it's going to be able to down the road prove that you have a strong trade dress.
Perfect. Thank you so much. It looks like that's all the questions that we have right now. If I'm wrong, if somebody out there has a question, then type fast. But I will just wrap things up by reiterating, if anybody didn't hear at the top of the hour, this webinar is recorded and it is going to be uploaded to utahbusiness.com/video within the hour. And you will have access to it there. You can watch it over, send it to your colleagues, whatever you'd like to do. I think that is it for today, and the hour is almost up. So thank you so much again to CJ and Parrish for joining, and to Mashoff Brennan for putting this webinar together.
Thank you, McKenna.
Thank you.
Thank you. I hope you guys have a great day.
You too.